Hello and welcome everyone. My name is Shubham Verma. I'm your Unacademy educator and I'll be teaching you legal reasoning. In this lecture, we are going to discuss constitutional falsehood. Basically, a disconnect between text and practices. So, what I mean by this is that something which is written in the Constitution is not actually being followed. So, yeah, those are something that we call falsehood. But before moving into all these things, let me just quickly introduce you myself. My name is Shubham Verma, as I've already told you, and I have done my graduation from Dr. Ram Manohar Lohia National University. I've done my post-graduation from University of Lucknow in political science, and I'm presently pursuing my PhD at Central University of Punjab, Batinda. I have cleared UGC NET GRF in 2019 with a 99.95 percentile. I have more than 6 years of teaching experience, and I remained academic head at IMS Learning Resources Limited, Lucknow Centers. Now, this is my Telegram group, Let's Fall in Law, where many students like you would be participating, discussing about very different things about law. This is the QR code you could use to reach me there. And this is Unacademy's YouTube channel. I invite you guys to please subscribe to this because this is your one-stop solution for all your CLAT and other law and exam journey. Now, this is the code again. You can scan this to reach us there. All right. Now, let's get started with the session. Okay, before getting into the lecture, let me give you quick priming because these things are very relevant in order to understand the lecture. The first thing is that you should know that as the codified constitution grows older, it forms less and less of the constitutional law of the nation. Like for instance, if you are aware about Article 21, then you know that it is just a very small article, but it is become very huge when it comes to the kind of rights that it is accommodating. Like it is being supplemented by a lot of judicial decisions, like dozens and dozens of rights are being acknowledged under Article 21. So if you read Article 21 only, then you might not be able to see what all is lying underneath there thanks to the judicial decisions and practices over it. I'm sorry. Yeah, here. Now, then there is a second thing that you should be knowing about, that is the basic structure. Now, we are not going into the most talk things about the basic structure. Rather, we'll be focusing about the less analyzed impact of the doctrine of constitutional text. All right. So what is this basic structure doctrine? Well, in very simple term, every constitution has its own identity. Now in India, our constitution too have some identity, and sure, the parliament has the power to amend that constitution, including the fundamental rights, but they could never change that identity. Now, what is that identity or what is that basic structure of the constitution was left open, right? And allowing the judges to develop the concept incrementally. Now, today, this basic structure is getting bigger and bigger, and we also need to see what is the impact of this basic structure on the text of the constitution. That is what the agenda for the today's session is. The next thing that you need to know, that although the judiciary can call any act or provision unconstitutional, but they could not delete it. So if you are aware about many things like the provision of adultery from Indian Penal Code is let's say called unconstitutional by the Supreme Court, but it is still lying there. Now, sure, the judiciary has the power to strike it down, but they cannot still strike it out of the statute book. It would still remain there, unlike the European Constitutional Code, which can obviously remove that, right? And fortunately or unfortunately, the treatment to the constitutional amendment is no different. That means if the constitutional amendment end up being unconstitutional, it would still remain in the constitution. And this is why we are getting to the falsehood. So yeah, those constitutional amendments which the Supreme Court called unconstitutional, they still remain in the constitution, and that's what we call the falsehood. So this is about what are those falsehoods are. Now, so let me quickly tell you brief about these structure because they are again relevant. Now, the legislature, they enact, amend and repeal the law. They also do amendment including to the constitution as well. Like the parliament do this for us. Now, executive's basic role is to implement that the law or the constitution or whatever that thing is, whatever the law that is being enacted by the legislature. And judiciary's role is basically to interpret and review them, right? To settle just dispute and administer justice. Now, so legislature would make the law. The judiciary would review them. And if the judiciary calls it unconstitutional, the thing would still remain in the act. And we just cannot make sure whether it is a true law or false law unless here comes the role of the executive, unless the executives, by doing some bureaucratic work, they just write it down under the citation, under the footnotes, that this provision, let's say, or this section or article has been called unconstitutional by the Supreme Court. So yeah, whenever you find a bare act or whenever you download an official act from the government website, right, then you would see that in the footnotes we would see things which says that this act has been called unconstitutional, this was added through the amendment, things like that. That is purely a bureaucratic work done under the law and ministry department and likewise, right? So this is how the three departments are collaborating together to make the law as it is and to appear whichever way it is now. So now, without any further ado, let's dive into and see what are those falsehoods that we can see in the Constitution. Okay, so the very first constitutional falsehood that I want to talk about is Article 31 C, which says that DPSPs are superior to fundamental rights. Yes, if you read Article 31 C, it clearly says that if a law is enacted to give effect to any of the DPSPs, then it would not become void even if it is violating Article 14 and 19, and these declarations cannot be questioned to the court of law. But unfortunately, this is a falsehood. Thanks to Minerva Mill and Keshananda Bharati judgment, these things are not effective or operative today. Now, if you read the Constitution again, Article 368, Clause 4 and 5 is saying that there is no limit to the constituent power of the Parliament, which means there is no limit to the amending power. That means the Parliament can amend each and every, in fact, they can overhaul all the Constitution. They can do whatever they want to do with the Constitution. But again, in the respect of basic structure doctrine, we know that that is not something which can happen today, and every constitutional amendment has to go through the judicial review process where the Supreme Court and High Court would see whether it is violating the basic structure or not. So this again is a constitutional falsehood. The third one is basically says that the text permits the Parliament to exclude jurisdiction of High Court to review the validity of decision made by the Administrative Tribunal. So under the 42nd Constitutional Amendment, which was done during the time of Indira Gandhi, it was the Administrative Tribunal found its constitutional backbone. They find mention in the Constitution, and in that we find that they have clearly written that if an administrative tribunal give a decision through law, those decisions can be over and above the High Court. That means the High Court cannot review the validity of those administrative tribunal. Sure, the Supreme Court can do that, but the High Court cannot do. That's what the text says. And that text says that even today. This again remains the constitutional falsehood. The next thing is that it's about anti-defection law. I presume that you guys are like fairly aware about what anti-defection law is. Now, anti-defection law simply means that when, let's say, a member after getting elected to a house change its alliance to the party, let's say he changed its party, now that is defection, and if he defect, then he would be disqualified from the membership of the house. Now this whole thing that is happening was beyond the interference of the court. Again, the court cannot review whether there was defection or not, whether the removal of the member was valid or not. So yeah, this was again thanks to paragraph 7 of 10th schedule. It was beyond the court. But again, this is something which is unconstitutional and is, even though written in the Constitution, is not operative even today. The last one, and perhaps the most interesting and striking one, is that how does today's judges are being appointed? Now, the Constitution says under Article 124, capital A, B, and C, combinedly, they say that there is a National Judicial Appointment Commission, which recommend for the judges' appointment and transfer. But no, it is not. It is unconstitutional, and it is the only constitutional amendment which was held to be absolutely unconstitutional. All of them were like all of the rest one were basically partially unconstitutional. But this is something which is absolutely unconstitutional. And we know that today the appointment and transfer are recommended not by the NJAC but Collegium. But Collegium is like a ghost which does not even appear in the Constitution. Not today, not ever. But today is that the case that something else appears for it, still it is not effective. So yeah, what appears in the Constitution is not true, and what does not appear in the Constitution is in fact the true. And this is the anomaly that is being created in our Constitution. These are the falsehoods. So generally, people would like to say, if you want to know about the Constitution, you must refer to the Act itself. But maybe considering all these things, this is not as simple as it looks. So yeah, there is something that we should be aware of. Now, I'll just show you all these provisions here quickly so that you could see it for yourself in the Act itself. So starting from the very first one, if you can see 31C here. Now, this again, this statement like highlighted here in red and this brown color statement have been called as unconstitutional. Partially, we say that this is called reading down, not striking down. Reading down is when a court narrow down a provision. So they are basically narrowing down. So yeah, this is something which is unconstitutional. They are not valid today. We don't have time to go into deeper into detail about these things. We might talk about these things some other time. But yeah, this is still in the Constitution and they are still not effective, not operative. Next thing is this Article 368, Clause 4 and 5. If you read it, it says that no amendment of this Constitution, including the provision of Part 3, made or purporting to have been made under this article, whether before or after the commencement of Section 55 of the Constitutional 42nd Amendment Act 1975, shall be called in question in the court on any ground. Right? And they don't leave anything for the doubts. For the removal of the doubts, it is hereby declared that there shall be no limitation whatever on the constitutional power of the Parliament to amend by way of addition, variation, or repeal the provision of this Constitution under this article. That simply says that the Parliament can amend whatever they want to. And there is no limit whatsoever. But thanks to the Minerva Mill case, it by reiterating the Keshav Nanda judgment, by reiterating the basic structure doctrine, held that clause 4 and 5 of Article 368 are unconstitutional and therefore null and void. Null and void. What is the effect? The effect is you can treat them as if they are not even existing in the Constitution. But you can only treat them as if they are not existing in the Constitution when you can see that they are not. But yeah, many people would not see it that way. Moving further, again, I have told you about the administrative tribunals. So yeah, these clauses, that is clause D and clause D of 323B and 323A, are again have been called as unconstitutional, which simply means that no matter what administrative tribunal or any other tribunal for that matter held tomorrow, high courts under Article 226 would have the jurisdiction. High court would have the jurisdiction to review them, right? That was said under L. Chandra Kumar versus Union of India, a very important, a very landmark judgment, right? It basically get back because that was the time when everybody was thinking that we were doing tribunalization of the courts. They are more of a executive courts and the judiciary's control over the justice is being removed by making slowly and steadily other courts which are basically more of a fast track court but more of a executive in nature. So this was something again you can see most of these provisions are about the judicial review. The Supreme Court is very envy about it. Whenever they see that their judicial review power is being affected, they are very, very much staunch about it. And you would come to know about this very soon, like in upcoming moments. Now, the second last one is the judicial review and the 52nd constitutional amendment, the anti-defection law, as you can see, paragraph 7, in in no ambiguous words, basically clearly saying that notwithstanding anything in this constitution, which simply means that it is irrelevant whatever else is written in the constitution, irrespective of whatever else is written in the constitution, no court shall have any jurisdiction, that is the power, in respect of any matter connected with the disqualification of a member of a house under this schedule. So this is clearly barring the court from reviewing or interfering in any decision related to the anti-defection law. But Supreme Court in Kyoto Holoan versus Dashiluhu called it unconstitutional. Now, interestingly, here they called it unconstitutional not for violating the basic structure doctrine. Rather, they called it unconstitutional because of lack of ratification from the legislature, state legislature. So there are two ways to amend the constitution. Basically, there are three ways, but under Article 368, there are two ways to amend the constitution. One, where you just need a special majority in the parliament. Two, where you, in addition to the special majority in the parliament, you also need the state ratification. That is, 50% of the state legislature should pass the resolution to that. But here, the parliament didn't opt for this, and therefore the Supreme Court called this as unconstitutional because the full procedure was not followed. So yeah, this was called unconstitutional for the procedural requirement, not for the basic structure doctrine. Now the final thing, the National Judicial Appointment Commission, that was basically brought to us with the 99th constitutional amendment. It was called unconstitutional. Absolutely and completely nothing was left to remain in the effect, and it was done under the in 2015 in the case of Supreme Court Educator on Record Association versus the Union of India. Now in this case, the Supreme Court clearly, Article 124 capital A, Article 124 capital B, Article 124 capital C, and everything else which was part of the 99th constitutional amendment, it was all called as unconstitutional. But if you still buy a new Bear Act, an official one, or if you download an official one, all these provisions are still lying there. So if anyone is reading that, they would think that National Judicial Appointment Commission is there, which is appointing the judges, which is transferring the judges, and which is basically ensuring the person recommended is of able and integrity. That is not true, because this thing is again being done by Collegium, which was made under the second judge's case and the third judge's case, and that is still effective today. And interestingly, what appears in the constitution is not in fact in reality working, and what does not appear in the constitution, that is the Collegium, is in fact working. So these are the constitutional falsehood, guys. I hope you find the session interesting. Thank you so much. See you in the next session.